addressing you on the protocol. And I probably said it. The judge himself recognised that limiting the control that was required by the treaty to control exercise through legal rights would offer a simpler solution. Those are his own words in paragraph 213 of the judgment at CB 2364 to 65. And in my respectful submission, that was correct, but he then failed to give the weight that observation deserved to his analysis of the meaning of the words proof of such control in the protocol. If, as he said, it's a simpler solution and it's easier and simpler to provide proof of legal control when requested by a host state to do so, that is indicative that that is the type of control that is required. It is also, as I've already submitted, a type of control which gives rise to a more certain and predictable test. Now, apart from the protocol, there are some other pointers within the wording and the structure of Article 1 itself that I wanted to draw attention to. And if we could therefore look at Article 1, it's at SB 22, page 2. And first of all, Article 1.1a, natural persons who are nationals of that contracting party in accordance with its laws. Now, there is a debate to be had as to whether that treaty provision is overlaid with a qualifying requirement of dominant or effective nationality as a matter of international law. But that argument was excluded for the purpose of the challenge by the learned judge as one that had not been raised below. So leaving that aside, what we see here is that the treaty says nationals of that contracting party in accordance with its laws. So that according to the treaty, that decision is to be made in accordance with Swiss or Czech law, as the case may be. So in other words, it's referring to domestic law for that way of qualifying as an investor. And it is fairly certain and predictable whether somebody does or does not qualify as a national according to the laws of the state which they purport to be a national. It's certainly a legal question, ultimately. It may be a mixed question of fact and law, but ultimately it's a question of law, domestic law, of, in this case, Switzerland. Then you have Article 1.1b, which is more complex than these provisions often are in the BITs that I've seen. Very often it simply says, for example, a case that I think Lord Bertarami and I were in, which a corporation incorporated in the Netherlands. And there were no further requirements of seat or economic activities. But the reason that's given in some of the commentaries for a more complex requirement is it prevents a company which is a mere postbox company, as it's sometimes called. In other words, it is a Swiss company, but it doesn't have any real connection to Switzerland or any economic activities in Switzerland, and it is incorporated there. So we have a system here where there are three cumulative requirements. The place of incorporation, which is clearly a legal fact, if you like, that is determined by the domestic law. The place of the seat, which is again another legal question. There may be some debate as to whether that's determined by the domestic law or international law or a combination of the two. And the question of real economic activities in the territory of that state. Now that is again ultimately a legal question, but it will turn on the facts to some extent, and it may be largely or entirely a question of public international law. So within 1.1b, one has references to domestic law and possibly also to international law. But again, B, in attempting to exclude the possibility of mere post-box companies claiming arbitration, it has overlaid two additional requirements: a place of seat, carrying out real economic activities, but it's relatively certain what is required, and ultimately those are questions of law to be determined by a fixed yardstick, namely what is the seat and where are the real economic activities are being conducted. So I'm just drawing attention to the fact that they do entail concepts of domestic law, and they are not, or not entirely, these two first provisions, questions of sui generis, public international law, using the terminology of Professor Douglas. And then we come to Article 1.1c, and the first thing we should note is that in contrast to B, which disqualifies Swiss companies which are simply nameplate or postbox companies, this can apply to a company anywhere in the world. And in that respect, I couldn't go so far as to say it is unusual, but it is an exceptional grant of jurisdiction to entities of third-party states. That is to say, not entities of one of the state parties. And in order to qualify, the putative investor company, which could be from anywhere in the world, has to be, or company or entity, I take George's point earlier, has to be controlled either by a qualifying national under A, which is referable to the law of the state that a person comes from, or a company which meets the second and third, but not the first requirement under B. And as I said, A and B provide a fairly clear and certain approach to be decided as a matter of law, and in fact, partly or largely domestic law, whatever domestic law is applicable. But according to the judge, 1.1c is rather different, because it isn't determined by reference to domestic law. It isn't actually determined by reference to any legal test. It is a sui generis test, just simply to be determined on the facts of practical control, without any reference to the presence or absence of a legal right of control, which he regarded as irrelevant to the outcome. And on his approach, the applicable domestic legal position, here under the trust, and the company, under Liechtenstein law, is to be ignored, even though the applicable domestic law position is relevant under both 1A and 1B. That is, in my respectful submission, indicative that the judge's interpretation of C is out of line and unsystematic. Another point to bear in mind when one compares 1.1b with C is that 1.1b defines legal entities in a way which is stricter than many treaties, because it goes well beyond the mere place of incorporation requirement to provide additionally that there must be the seat in the home state and there must be real economic activities there. On the other hand, because Article 11C extends protection to legal entities worldwide, according to the judge, in unspecified circumstances, to be determined by the arbitral tribunal by whatever they think is the right measure of control without reference to domestic law or any fixed or certain test. Again, I submit that that is an odd and unsystematic way to read the third of these provisions in this sequence. So unless I can assist you further on the wording for the moment, my lord, I'm going to move on to the fifth head of argument, which is to take you briefly to two cases, the UCOS case and the Argonauts case. And the reason for this is that these are the only two cases in what the judge called the ITA jurisprudence, which considered discretionary trusts. The UCOS case was a permanent court of international arbitration case, which we respectfully submit is particularly helpful and persuasive because of its close factual parallel to the facts of the present case. And we have that in Legal Authorities, tab 70, page 1. The tribunal consisted of E48. I don't know whether he's known to you, but he was formerly the Canadian ambassador at the United Nations. In fact, he chaired the Security Council in that diplomatic capacity. Also a very well-known lawyer and arbitrator. Dr. Charles Conseil was a very experienced Swiss arbitrator, and Judge Stephen Schwabel. Now, Judge Stephen Schwabel was one of the most eminent international jurists, well, still is as far as I'm aware, professor of Harvard Law School, deputy legal advisor to the US Secretary of State, US judge at the International Court of Justice for some 19 years, I think, and then its president for the last 3 or 4 years, and then sitting in many international arbitrations and international panels. Now, if we could go relatively quickly through this, and then I'll show you the relevant parts, you'll see, if we could go please to page 168, that the Energy Charter Treaty in paragraph 435 has a straightforward definition of investor, and 5 lines out, it says Article 1.7 provides the investor needs with respect to the contracting party, a company or other organisation organised in accordance with the law applicable in that contracting party. So there's a very simple definition. But what happened in this case is there was reliance on the fact that the company did not qualify because of what's called the denial of benefits provision. And if we could please go to 169. You see the start of the discussion, are the claims barred by the denial of benefits provision, Article 17 of the ECT. And the relevant provision, Article 17, is on page 170. And this is where the control issue came in this case. Each contracting party reserves the right to deny the advantages of this part to a legal entity if citizens or nationals of a third state own or control such entity, and if that entity has no substantial business activities in the area of the contracting party in which it's organised. And it says at 440, the foregoing denial of benefits clause have been the focus of conflicting arguments of the parties. The tribunal summarises and evaluates those arguments in the sections that follow. And if we then please go to page 177, you see at paragraph 462, the tribunal had an organisational chart, which in this version appears at page 226, but I have had handed up a coloured copy of that expanded. And this is a bit easier to use than the one. Basically, you see the structure. The relevant claimants were those at the bottom. UCOS, or near the bottom, UCOS Universal, Hully Enterprises, and Veteran Petroleum. And those three claimant companies, which were all shareholders in UCOS Oil Company, the Russian company, were held through this structure, which you see if you go up the page, through nominee companies, in each case, and then trusts, the line above that, and then the blue and the green and the red arrows indicates red as the settlors, in each case. This is the key in the top left. So they all had settlors who were largely the oligarchs in question. So if you read across the top of the red arrow, Pavo Trust, Dubov, Lebedev, Bruno, Nevzlin, Nosky, and so forth. Then the blue arrows are who was the protector, and then rather similar to our case, I should have mentioned Khodorkovsky on the left as well. The blue arrows correspond in most cases, or all cases, so that the person who's the settler is also the protector, blue arrow coming down to each of the entities, and then the beneficiaries as the green arrow going back up, and these are all discretionary trusts, so in the Khodorkovsky one, it's an open class of beneficiaries and Khodorkovsky. The next one, open class of beneficiaries, including Khodorkovsky, Nevzlin and his issue, and then similarly at the top of each of the green arrows. So essentially, very much the same structure as we have in our case, except governed by Guernsey law. So if we could now go back to page 177, please. This is where the factual background is set out, and the features of those trusts, which I've shown you in diagrammatic form, are explained in more detail. And then if we go on to page 190, parties' submissions on control are set out. And they had expert evidence as well from Mr. Mann and another leading counsel, I think, as well. And then if one goes through, starting at page 194 to page 204, the submissions that were made are very much the same submissions. Yes, Mr. Green was the other one. And I'm not going to take you through all of this, but they are very much the same things that we have in issue here, right up to page 204. But we just pause at page 199, please, at paragraph 515. The tribunal concludes that the Guernsey trusts are valid and effective as a matter of Guernsey trust law, and vest ownership and control to the trustees within the framework of the trust instruments. Tribunal now proceeds to consider the key issues the respondent argued affected ownership and control of the GMSs under Guernsey law. And then they considered various points, respect to the fiduciary. I won't go through all of those points. Then page 200, the same as the judge held in our case, at paragraph 521, the tribunal concluded in respect of the protector's powers are not entirely discretionary, they must be exercised in a fiduciary manner and for the benefit of the beneficiaries. And it's the same finding as we had in our case. And then at paragraph, on page 201, paragraph 525, the tribunal discussed the anti-Bartlett provisions which are primarily meant to exclude liability in the event that the trustee fails to take certain steps with regard to the trust property. This is the one where it says that the trustee doesn't have to manage the assets of the trust. And exactly the same provision as we have in the Liechtenstein trust in our case. There was then a question in the case about call options, which we can pass over. We go down to page 203, at paragraph 532. They dealt with the Saunders and Vertier point. In the tribunal's view, the determining factor is that the rule in Saunders and Vertier was not exercised. Its mere existence does not lead to the conclusion that because Article 48.3 of the Guernsey Trust Law may be evoked at some later point in time, trustee is not the owner or in control of the assets settled into the trust under Guernsey law. Now, we had a related point in our case because it was one of the arguments that was run by the arbitration claimants in this case was because Mr. Sava could change the trustee as a protector, something he hadn't done. That indicated that he had some level of control over the company, or over the shares, and therefore over the company. In parallel, they said that it's something that hadn't happened, and it was not relevant. In our case, the Saunders and Vautier point doesn't arise because there is no Saunders and Vautier right in relation to a Liechtenstein trust, because there was no equity, there's no equitable ownership. They do refer there in passing at 533 to the existence of letters of wishes. And this is quite a standard thing in relation to a discretionary trust, that the settlor will have communicated to the trustee his wishes as to how the trustee may wish to exercise the discretions. Now, in the present case, the judge found that there were probably letters of wishes, or at least some written record of Mr. Stava's intentions. There had been an order prior to the trial that those letters of wishes be disclosed, but no documents were disclosed pursuant to that order. It was therefore, the position was that we weren't able to make points that we might have been able to make by reference to the letter of wishes. The judge made a finding that he didn't think the letter of wishes would have revealed anything other than that Mr. Stava intended to benefit his family. But that was, I'm not sure on what basis he made that finding. I don't necessarily dispute it, but the point is we didn't have the letter of wishes. And Mr. Stava, who's in the position of the trust, is to be ascertained as at the 31st of December 2011, 1st of January 2012. The letter of wishes that was in place at that time, assuming that there was one, was not disclosed. And therefore, one is left with the position that it was Mr. Stava's evidence that he had contributed the full ownership of the shares into the trust for succession planning purposes and as a subsidiary purpose for asset protection in case anyone came after him. So just as to mention that, because the letter of wishes is referred to there. And then if we go on, please, at page 203, well, starting at the bottom of this page, if we could just see it in a bit more detail. Conclusion. Finally, and before summarising its conclusion with respect to the trust issues in the instant case, the tribunal notes that transferring ownership of assets to a trustee pursuant to a trust instrument is a centuries-old institution of the English common law. Settling certain properties into a trust, thus transferring legal ownership to the trustee and adopting provisions with regard to the beneficiaries, including leaving their establishment at the trustee's discretion, subject to the powers of a protector as the case may be, is a well-established legal institution, the common law, which is recognised internationally today pursuant to the Hague Convention on the Law of Trusts and their recognition. Tribunal sees no reason to unsettle a centuries-old legal institution when the trust instruments at hand do not depart from standard forms used in countless other similar settlements. To do so would put into question the validity of the very concept of trusts at a time when their recognition goes well beyond the common law countries. Indeed, in recent years, trusts have found a significant measure of acceptance in some civil law jurisdictions. have Liechtenstein as an example of that. Well, there was no evidence before the tribunal that they are accepted instruments in Russian law. This is the question which will remain open for argument in any merits phase of the case in connection with respondents' contention about the claimant's unclean hands and about the claimant being the instrumentality of a criminal enterprise. And then they made their findings that the claimant is wholly owned by GML Gibraltar, which in turn is owned by the 7 Guernsey trusts, and so on. So, to sum up, the eminent tribunal rejected the argument that because certain of these oligarchs, as I've called them, the individuals listed across the top, were multi-hatted in the sense that they were settlors in most cases, protectors, and amongst the list of potential discretionary beneficiaries, so exactly the same as Mr. Stava, settlor, protector, in the class of potential beneficiaries. They rejected the argument because of that they were in control of the trusts so as to be disqualified under the denial of benefits provision in the Energy Charter Treaty. Now, just look at the way that the judge dealt with that in the judgment. In my respectful submission, if any case in the ITA jurisprudence is of any relevance, is this one. Not any of the others that are going to be cited to you in the next day or two. And this is an eminent tribunal, and they dealt with it in detail, and they made an important finding. And then the way that the judge dealt with it was at paragraph 187 of the judgment, CB 23, page 56. And my respectful submission, the judge rather missed the point here, because when he referred to the clause, and he refers to the finding at paragraph 517. And he then says, this is about 10 lines down in paragraph 187, it is fair to say that the tribunal regarded the legal position under Guernsey trust law as effectively determinative of this question. And that's right. But they not only regarded it as determinative of the question as a matter of Guernsey law, but determinative of the question under the treaty, under the relevant Energy Charter Treaty. And he then says, and this is where my respectful submission goes wrong, he says, however, this may have reflected the case management decision at 509 to defer the issue of whether the former shareholders may have retained control over the shares transferred into the trust as part of a structure they have established and used at various points for fraudulent or criminal purposes, addressing only certain issues which arise within the more narrow framework of Guernsey trust law. With respect to the judge, there was a different question which was deferred, namely whether the opposing party, that is the Russian state, was able to run a veil-piercing argument so as to go behind this trust structure and to get a second bite at the cherry. That's referred to at paragraph 436, LA 7169. So the issue that the tribunal addressed is, assuming that the trust structure is valid and effective, can it be said that there was control of the relevant individuals? And that is directly parallel, with great respect to the learned judge, that can't be dismissed on some sort of case management reasoning. That is directly parallel to the issue that is in the present case, because we are in a situation where it's common ground that the trust is valid and effective, and yet it's somehow still being contended that under the trust, Mr. Stava exercises or had the right to exercise control, and in such a way that that should be regarded as control by him for the purpose of the treaty. Now, that is exactly the same argument that was dismissed by the eminent tribunal in this case. My lords, there's only one other arbitration case that deals with discretionary trusts. And I have to accept that, as we cite it, is in a slightly different context, because that is the question of not who is an investor, but whether there is an investment. That is, harking back to one of the questions that my Lord Justice Popplewell asked yesterday, that is one of the contexts in which trusts do sometimes come up in the ITA jurisprudence. If you are in such a trust where there is a beneficial ownership under the trust, can you say that you hold an investment? And now, of course, beneficial ownership, or equitable ownership as we call it in English law, is a form of legal right, and particularly where there's a Saunders and Vautier ability to collapse the trust and call for the assets to be transferred to you. But that is not our situation in the present case. Let's just look very briefly at Arbitration, which is LA 86, and I only really want to show you, I think, one or two paragraphs. So this was an entirely discretionary trust under which the tribunal held that the beneficiaries, or the potential beneficiaries, because they're not actual beneficiaries, do not have an investment. It was focused on the question of whether there was a qualifying investment, not on the question of whether the person was a protected investor. And the question was, does a discretionary beneficiary have a sufficient interest to meet the requirement of having or holding an investment in the applicable BIT? And I just wanted to show you their conclusion on that, which is at LA 86, page 68. In paragraph 224. They say, in conclusion, none of the cases discussed so far serves as a basis for the premise that a discretionary beneficiary of a trust or an interest holder has standing to bring an investment claim in arbitration proceedings. In all these cases, in the words of the RECO tribunal, the investor's rights were real and not conditional. In the present case, that's to say under this discretionary trust, the claimant's rights or interests were dependent on the decisions of third parties. First on the decisions of Mr. Arbitration and the trustees, and later on the decision of the trustees. In the meantime, the claimants, as the potential beneficiaries, had no right or interest in the trust's assets, but only the hope of benefiting from the trust. And the value of that hope resembles the value of an interest that a person with an expectation of receiving an inheritance might have. In the court's view, a hope is not an asset. It's comparable to a conditional benefit. And as can be seen from the cases analysed below, conditional benefits have not been considered as assets capable of qualifying as an investment. Now, before I move on to my sixth point, there was just, I think, one other point I wanted to deal with in the judge's reasoning. And that is, if we go to paragraph 215, Roman 5, that's at CB 23, page 66, the judge made some observations by reference to an article by Odysseus Repusus. And I'm not coming back to the question of the somewhat improbable consequences, which he refers to in the last sentence. But I just want to highlight that this particular passage, which the judge refers to here, mentions the findings of the tribunals in 4 cases. Saba, Fakes, Emelec, Guardian Fiduciary, and Bluebank. And he says that in each of those cases, the findings of the tribunal reveal that the relevant inquiry is one of substance, not form. Now, with great respect to the judge, we don't agree that for one moment, because now I don't want to say too much about this, because it may be that my learned friends are not planning to rely on these cases or to support what the judge said there. But these four awards that are listed there do not support the judge's position in paragraph 215, that the legal position under a trust structure is a matter of form and not a matter of substance. And we've set that out and referred to these cases in paragraph 52 of our skeleton, CB 18, page 19. And if lordships are content, I'll pass on and just say that we don't accept that that is the correct interpretation of those cases. I'll see how my learned friends develop those matters if they do. And so the last head of my argument, the sixth one, is to say something about the other ITA awards by the respondents, and which were referred to as the judge. And you'll recall that the judge considered, and this is paragraph 215 Roman 2 in the judgment, that his conclusion was supported by, quotes, the majority of the ITA jurisprudence, unquotes. With great respect to the judge and to the respondents, we submit that this is wide of the mark. First of all, there is no, these are not authorities in the English sense of the term. There's no system of binding precedent in public international law. Even the International Court of Justice is not bound by its own previous decisions under Article 59 of the Statute of the International Court of Justice. Secondly, the only cases which are discretionary trust cases are the relevant ones, and they don't, the judge didn't accept our submissions in relation to those, but they are more important than the other cases that either don't refer to trusts at all, or refer to a different type of trust. Most of them don't refer to trusts at all. They are just cases where the tribunal had some reason for saying that they would decide the matter on facts rather than by reference to a legal test. And it is actually questionable whether in any of these cases the decision was actually what we as English lawyers would call the ratio decidendi of the case. Not that that's a term that's used, obviously, in public international law. I appreciate that.
The one Latin phrase they don't use, is it?
Well, yes. I won't take up the invitation to comment further on that. As we point out in our skeleton argument, in all of the awards canvassed in the judgment, other than the MAKAE case, where the de facto approach was common ground but failed on the facts, so that's not exactly a precedent, and the Italba case, where de facto control failed on the facts, and therefore the tribunal did not have to resolve an argument before it about exactly what test should be applied regarding control, then I think I'm right in saying that all of the other cases did involve a legal right or a property interest of some sort, with de facto control as an additional element. So when these cases are cited to you by my learned friends, one does have to be very careful. They may say something about de facto control, but did it actually make a difference? And was it actually contested in that particular case? And now, the two cases that the respondent skeleton now relies on in particular are the von Piesold case and the BMEX case. In each of those two cases, however, the claimant or the claimants had a direct or indirect equity stake in the companies, which was in excess of 40%. So they may not have been the absolute shareholder, but they were the relative majority. And whilst the tribunals in those cases did make somewhat broad and particularly well-reasoned statements about de facto control, they did not uphold jurisdiction in a case like the present one, where the relevant claimant is controlled supposedly by someone who had no ownership right or legal right of control at all. A lot of these cases are not cases about control for the purpose of the ratione personae question of qualifying as an investor. Many of them are questions about whether there is a sufficient nexus between the qualifying investor and the investment. And so one would largely search in vain in these cases for a coherent explanation of what qualifies as de facto control, which is really why the ADT in Bolivia majority, David Caron and one colleague, found that factual control as an approach was too vague and uncertain and unpredictable, and why we submit correctly, Professor Douglas wrote against it and preferred to have a test based on the domestic private law position using established property and company law concepts, as that would be more predictable and certain. So for all those reasons, on the first ground of appeal, we say that the judge, having correctly held in paragraph 171 that Mr. Stava had no proprietary interest in the shares and no legal right over them or the company, which he summarised as meaning no de jure control, after the shares had been settled into the Krona Trust, he ought then to have held that the Czech Republic had not consented to arbitrate with Diag Human SE, and that the Czech Republic's jurisdiction challenge succeeded because Diag Human was not controlled by Mr. Stava in the correct legal sense required by Article 11C. So far as our second ground of appeal is concerned, which I pursue, I would stress we are not challenging the fact findings made by the judge. Our points on this part of the appeal are also legal ones, although I think in some respects I do seek to supplement the fact findings made by the judge, but without challenging them. Very broadly speaking, there are two parts or two themes in this part of the first part of this appeal, the second ground. And first is that the facts found by the judge in the present case were insufficient in law, cannot be relied upon in law, to found de facto control of Diag Human by Mr. Stava. And second, and it's related to that, but in finding that there was de facto control, the judge considered certain factors which, whilst we don't dispute them as factors, are in law irrelevant to the question of de facto control, and are factors which he's imported from a different area of inquiry, namely whether there was a qualifying investment. In the language of this area, they are ratione materiae points concerning the making of a protective investment. They're not ratione personae points as to whether Diag Human is a qualifying investor. Now, on the first point, which is a principal point here, as a matter of analysis, the relevant matters which are said to evidence control of Diag Human by Mr. Stava can only be one of two things. They can be first of all, matters or conduct of Mr. Stava within the framework of a valid trust structure and respecting the trust structure. Or, potentially, it could be argued that they were conduct outside of the trust structure and not respecting the trust structure. Those are the only two possibilities. It's either under and within the trust, or in some way outside the trust and not respecting the legal framework of the trust. And it's really the first one that's the most important, unless and I hear from my learned friends, they are in fact going to argue that somehow what Mr. Stava did was outside the legal structure. I've always understood it to be common ground that there was a valid and effective trust, and they are seeking to rely on what he did within the framework of the trust structure. Now, so far as that is concerned, insofar as any control which Mr. Stava exercised was done within the trust framework and respecting the trust structure, we have a simple point, that it was not done in his own right, but was by virtue of him being permitted to act by the trustee for and on behalf of the trust. And it is therefore not to be characterized as a matter of law as control by him. Instead, if necessary, it should be characterized as control by the trustee, his principal, on whose behalf he was acting. Now, on this aspect, the learned judge made the correct fact findings, although, as I say, I may seek to supplement them or explain them by reference to some of the evidence, but he did not follow them, in my respectful submission, to the logical conclusion, because he ought to have held that the practical control which he found as a fact that Mr. Stava was exercising was not in law Mr. Stava's control, but instead that of the trustee exercised through Mr. Stava as his agent. And just to be clear about this, in general, and under Liechtenstein law, a trustee is not a nominee or an agent for a settler, or a particular beneficiary, or even for all the beneficiaries together. When you set up a trust, and that's the position here, the trustee is the principal. And the judge accepted that Mr. Stava held the legal rights of control on behalf of the others. And if we could look at the judgment at CB 23, page 67, judgment paragraph 216, Roman 6a, he says, the effects of the matters in 1 to 4 above are as follows. While Mr. Stava held the legal rights of control on behalf of others, see Annex 3, 61.4, there was no realistic possibility of any conflict of interest between Mr. Stava's interests and those of the Corona Trusts. And he therefore had the same scope of decision-making. In fact, he had economic attributes, and his position cannot be equated with that of a conventional director. Now, I'll come back to all of those points in a moment, but I just want to focus on the reference to 61.4, which refers back to Annex 3, which we have at CB tab 23, page 112. And in Roman 4 there, Mr. Stava's legal, this is his conclusions in the annex, Mr. Stava's legal decision-making powers as chairman of Diag SE, holder of the bearer shares in Diag SE, and as protector of the Corona Trust. So these were the only capacities in which he had any powers, were not in the first two instances held in his own right, that is, his powers as chairman and as holder of the bearer shares. And in each case, so now including his capacity as protector, were not exercisable solely by reference to his own interests, but only in what Mr. Stava believed to be the best interests of Diag SE, the Corona Trust, as appropriate. So, to sum up, the judge held as a fact that as regards being the chairman of the board and holding and voting the shares, he was doing so for and on behalf of the trustee, because they were not held in his own right. And I'll supplement that with the joint memorandum of the experts, which was agreed on that point in a moment. Now, so far as earlier in Annex 3, I might need to just show you some earlier passages. So if we could go back, please, to page 103 at paragraph 29, Roman 11. This is where he's summarising the Liechtenstein law. He says, an agent who acts on behalf of a trustee must act in an orderly, diligent and conscientious manner in what they believe to be the best interests of the trust, must follow any lawful instructions the trustee gives, and cannot exercise the rights delegated to them in their own interests or by reference to extraneous considerations. So that applies to Mr. Stava insofar as he was acting for and on behalf of the trustee as chairman of the board and holder of the shares. And then if we go, please, to page 107, paragraph 39, the experts' joint memorandum referred to Mr. Stava acting as an agent of or custodian for the Corona Trust when holding and voting the shares. And I'll show you that in a moment. But it's important that it's when voting the shares. And then if we could please look at paragraph 41, the last two lines of paragraph 41. He says, as will be apparent from my summary, there was no undisputed Liechtenstein law evidence that Mr. Stava's physical possession of the shares made him the owner to the extent that he was holding the shares, as both experts accepted he was, as agent or custodian for the Corona Trust. And then 42.3, you just see that, Mr. Stava held the shares either as a custodian or agent for the trustee and had taken possession on behalf of the trustee. And that was something that, if you look at the beginning of that paragraph, was confirmed in cross-examination by Dr. Batlina. And then if we can go to see Roman 5, which might be further down that page or over the page. Right, yes, it's the top of the next page. The Corona Trust was the owner, even though Mr. Stava held the shares, because he was holding the shares as the agent's trustee. And then and then the next one, Roman 6, when Mr. Stava was holding the bearer shares, he was holding them as agent only. And then if we could go to paragraph 44, and perhaps see the whole of 44, the last 8 lines. Yes, I think picking it up just over halfway down. So too of Mr. Stava from the 27th of May 2011, who held the shares as agent or custodian for their owner, the trustee on behalf of the Corona Trust. This is the consistent effect of the evidence of Mr. Reitner and Dr. Batlina, as I've sought to show, and it's fatal to the arbitral claimant's attempts to depart from their pleaded case and argue that Mr. Stava was the owner of the shares on the 1st of January 2012. That's sufficient to dispose of the point, but I would in any event have held that it was not open to the arbitral claimants to advance it against the procedural background I've outlined. And then if we could go over the page to paragraph 49. However, Mr. Stava was not exercising legal powers of control held by him in his own right, and those powers could not be exercised exclusively in his own interests. The immediate source of those powers was Diag SE itself, and then so far as the shares in Diag SE was concerned, we have all the findings that he was acting in relation to them as an agent for and on behalf of the trustee. Now, as regards him being a protector, which you remember the judge in that paragraph I showed you had 3 capacities in which he was acting. One as chairman of the board, one as holder of the bearer shares, and thirdly, in his own capacity, if you like, as protector. He was subject to the terms of the trust and to the same duties as the trustee. And so if we could just look very briefly at the judge's findings in relation to that, that's CB 23, page 100, first of all, paragraph 23, Roman 1. Where he says, and I'll briefly show you the trust deed in a moment because this will become a little bit clearer if I do. Mr. Sava was a settlor by virtue of the definition, the settling of the shares into Diag SE, into the Corona Trust, and the original protector. The protector was entitled to nominate a person who would become protector once they ceased to hold office, with the trustee having power to nominate a protector during any period in which the office would otherwise be vacant. And then if we go to page 102, 29.3, the same duties are owed by the protector of the trust. That is the same duties that he's discussed on the trustee in the previous paragraphs, who cannot hold the trust assets in the trustee's place, cannot hold the trust assets in the trustee's place, or deal with third parties in relation to trust assets by virtue of the office of protector alone, as opposed to when acting on behalf of the trustee, e.g. pursuant to a power of attorney. And then paragraph 32 on page 103, where he sets out that there was an issue as to whether a protector who was also a beneficiary could exercise the power to remove the existing trustee and appoint himself as a trustee and distribute trust property to himself. And then he made detailed findings in relation to that. So in other words, as a protector, in which he did have a personal role, but with only very limited powers and subject to the trustee terms, Mr. Sava was permitted by the trustee to have practical control of the company, but this was not control in his own right or in his own interest. And we respectfully submit that it shouldn't be regarded in law as control by him, but by his principal, the trustee. And now, as regards him as a protector, I said I would show you the trust deed. He only had very, very limited rights. This is SB 48, page 13. He had the right under 22.1, we could just have, thank you very much, of appointing new or additional trustees. That's in 22.1. And he had the right under 22.2 to remove a trustee. Those were the only rights he had qua protector. But they were not, in fact, exercised during the relevant period up to the 31st of December 2011, 1st of January 2012. So to that, in that respect, they are hypothetical. And in any event, the learned judge held that those powers did not give Mr. Stava legal control over the trust or its assets. And in exercising the practical control over the company as a board member and voting the shares at shareholder meetings, Mr. Stava was simply doing what he was permitted to do and authorised to do as an agent for and on behalf of the trustee. And it was the latter who actually held the right of control, and so that any control was not Mr. Stava's, it was the trustees. Now, I made this point from the very beginning of the case, and one of the key documents in the case, which the judge had referred in the paragraph I showed you, was the joint memorandum of the experts, which we have. This, that's a rarity, that we had a lot of agreement between the experts on all the relevant matters, which have been largely questions formulated by the judge at a case management conference. So if we look at SB tab 33, you'll see this. What's the relevant page? I apologise. Probably in the very next tab. 72. 72. Yes. Yeah. Sorry. Do apologise. I don't know where that came from. So this was the joint statement of the experts to which the judge referred. It's a landscape document. And do your lordships have it in hard copy?
No, we don't have a hard copy.
No.
Would you like hard copies? Because
If it's said to be a key document, we better have it.
well, I'm not saying you have to read every line, but there are some paragraphs are important. Yes.
Well, if you have it, then
And not only that, but we have blown it up because the paragraph numbers are incredibly small and difficult to read. So if I could hand those up.
So you asked a little effort. Those behind you could tell us when you're going to a document that isn't in our hard copy bundles. At least my Lord Justice Miles and I will
I do apologise. I'm afraid I haven't got a firm grip of what is in the bundles and not in the
as a
bundles.
practical matter, you may be able to answer.
Yeah, I don't think there's going to be a lot, not from me anyway.
thank you very much.
So this is the joint memorandum. As I say, it was a very, very helpful document. I'm not going to take you through many parts of it. They set out their instructions on page. The numbering is in the bottom left. So I'll go on here. Page 3, their instructions and the questions that have been formulated for them. And in each case, if you go to page 4, the emboldened part is the question that they were asked to answer, and then the rest is their agreement until as you go on. Everything is agreed then through until you come right to the end of that relevant section after another 2 or 3 emboldened questions. And then the areas of disagreement you get on page 8 in respect to that heading. But that doesn't matter for present purposes. What I want to show you is starting on page, it may entirely be on page 12, areas of agreement on issue 2. And the question here was, when allowed by the trustee to retain possession of the share certificates and vote the shares on behalf of the trustees, to what obligations, if any, was Mr. Stava subject when so doing? Was he free to vote the shares in his own interest? Would the trustee have acted in breach of the trustee or the rules applicable to the trust if it permitted a third party such as Mr. Sava to have possession of the share certificates and to vote the shares as he wished? And the reason I say that the numbers, even on this copy, are still very small. The first paragraph is paragraph 32. In the absence of specific instructions from the trustee, Mr. Stava was allowed to exercise the shares to the best of his knowledge and belief, but he has to protect the interests of the Corona Trust as an agent of the trustees. He was obliged to exercise the voting rights in an orderly, diligent and conscientious manner, may not be influenced by extraneous interests, and has to make his decisions on the basis of appropriate information for the benefit of the Corona Trust. The duty of loyalty and care, obliged to follow their instructions, his principal's instructions. Mr. Stava had to surrender all benefits and render accounts. If Mr. Stava wished to pursue interests conflicting with of the principal, the trustees, the consent of the sufficiently informed principal was required. And only got a little bit more of this. 33, for many practical purposes, the interests of the trustees of the Corona Trust will be aligned with the interests of the beneficiaries. However, in cases where the interests of the trustees and beneficiaries are not aligned, Mr. Stava has to vote in the interest of the trustees of the Corona Trust. To be clear, Mr. Stava cannot vote in the interest of a single beneficiary, but needs to vote in the interest of the Corona Trust. Any specific benefits to a beneficiary are a decision of the trustees, not the agent that votes. And then I go to 36. The trustee has not acted in breach of the trust deed or the rules applicable to the trust if he permitted Mr. Starver to have possession of the share certificates and exercise the voting rights, as long as control over the shares remained with the trustees, such as if Mr. Starver acted as custodian of the certificates, or Mr. Starver acted as agent of the trustees, and he was subject to the above restrictions on voting. Control does not automatically require a written contract between Mr. Starver and the trustee. The trustees would be in breach of the trust deed if they permit Mr. Starver to vote the shares in his own interest. Let's see paragraph 33. Thus, the trustees would have acted in breach of the trust deed or the rules applicable to the trust if they permitted a third party, such as Mr. Starver, to have unrestricted possession of the share certificates and to vote the shares as he wished. And the experts note that Mr. Rabanza is a board member of Diag Human SE and also director of the trustee, and therefore the trustee is normally fully aware of the decisions and the votes taken, so long as this setup is maintained. So I think that's all I need to refer you to there. In support of the point that looking at the capacity, as I think Lord Justice Popplewell termed it yesterday, in which Mr. Starver was acting, I relied on a case called the Gramercy case, Gramercy against Peru, and this is Legal Authorities tab 89. And like many of these cases, it's a long award. It's a relatively recent one, 2022. The passage I relied upon is at page 138, paragraphs 639 and 640. And it says there, the claimant's counter-argument. The claimants say that control may be achieved through indirect majority ownership, as well as other arrangements that constitute legal or de facto control. But contrary to the claimant's underlying assertion, control can only be exercised at the ownership level, not at the level of administration. Managers, directors, and administrators do not control the company. Their role is to adopt decisions and to make declarations of intent on the company's behalf. And that was a proposition that was accepted in that case. And when the judge looked at this, as I showed you earlier, the judge distinguished the current situation from that was being argued about in the Gramercy case. And if we can go back to the judgment on that, it's paragraph 216 of Roman 6, that's at CB 2367. At D, and I mean this where he refers, he says at D, for these reasons, the position of Mr. Starver in this case cannot be equated with that of a conventional director or manager of a company or an agent acting on behalf of a principal, where I accept that de facto control for Article 11C purposes will be difficult to establish. The closest analogue to a conventional company director in this case is not Mr. Starver, it's the trustee. So if he says that for these reasons, he distinguishes the case of the conventional agent or director or manager of a company. And the three reasons are those that are set out in A, B, and C of Roman 6 in this paragraph. And I respectfully submit that these are not good reasons, and I shall explain why. The first reason he gives is in A, there was no realistic possibility of a conflict of interest between Mr. Starver's interests and those of the Corona Trust. Well, that may well be the case in virtually every situation where an agent and his principal are working hand in glove. it's very, very normal in a commercial context for an agent's interests to be completely aligned with those of his principal. They both want to get a contract, they both want to get a good deal, they both want to make a profit. The principal benefits from the contract, the agent benefits from the contract. The mere fact that an agent and a principal have no conflict of interest between them doesn't mean that one throws out of the window the concept that the agent is acting for and on behalf of the principal, and the conduct of the agent is to be attributed to that of the principal. It is, in great respect to the judge, simply irrelevant. The second point he made is that Mr. Sava had the same scope for decision-making, in fact, in relation to the conduct of Diag SE's business after June 2011, as he had when he was the owner of Diag SE. Well, again, so what? That he had the same scope of decision-making if the capacity in which he's exercising that scope is now fundamentally different. Previously, he was doing it in his own right as the owner and shareholder. Now he is no longer the owner and he's no longer the shareholder. And as I've shown you, with the judge's findings supplemented by the joint memorandum, he is acting as shareholder and director for and on behalf of the trustee as an agent, so that his conduct is no longer his own conduct in law, it is the conduct of the principal. And he is therefore, the fact that as an agent, his decision-making scope is the same as when he was a principal is neither here nor there. And in great respect, the learned judge has erred in relation to paragraph B there as well. And then we come to C, which is somewhat hard to understand what he means by the economic attributes of ownership. But even so, let us assume, it could be the case that under the trust structure, the economic aspects of ownership are being dispersed between various people. But let us assume that they haven't been dispersed. Surely it is the trust that now has the economic attributes of ownership, if that means that the only asset of the company, by the way, at this point in time, was its right to pursue its commercial arbitration award. So then the economic attributes of the company that held the right to pursue the arbitration award have been entirely contributed to the trust, because the shares in the company are now in the trust. So in what sense can it be said that Mr. Stava had the economic attributes of ownership? He didn't. The rights to dividends or the proceeds of recovery from the commercial arbitration award would flow through the company to the trust, and they would not flow through. So if you look at it from an economic point of view, that is another false and incorrect point. And in fact, you should bear in mind that the purpose of his succession planning was precisely in order to ensure that he didn't have the economic attributes of ownership, or if it was succession planning, or even if it was asset protection, because he didn't want people to get at his assets. He consciously and deliberately, and with legal advice, alienated those assets and placed them entirely in the trust.
It's not quite the same point, but it fits with 242 of ADT, that control, even if it means de facto control, is not control simply in an abstract sense, but is controlled by virtue of an ownership interest.
Yeah. I mean, that's why
that
there's...
doesn't depend upon an agency or capacity analysis, but it's another way of reaching the same conclusion.
Exactly, and that's why before I even started on the first ground, I said yesterday, and it may be back in the midst of time now, but the two grounds had a common theme. I won't repeat what I said, but that's why, because you could view the two arguments, the first ground and the second ground, as almost two sides of the same coin. that they are legally distinct, but they do have a common theme, and that is that the rights in relation to the shares have been deliberately and consciously, with legal advice, alienated, so that there is no ownership and there are no rights of control. And thereafter, any control that Mr. Sava is permitted to exercise on behalf of the trustee, he as the joint experts report said, is doing, and the judge found this, but he didn't make it quite as clearly as in the joint memorandum. He is doing for and on behalf of the trustee as an agent, and subject always to the fact that control rests with the trustee. The legal concept of control rests with the trustee. That was in paragraph 36, I think. So then the judge made, elsewhere, he made findings that Mr. Stava was in charge, he was the driving force behind the claims, and it was his knowledge and experience and influence that was guiding the company. And that, as a practical matter, may be entirely correct. But again, as a matter of legal analysis, it doesn't alter the position. You could have, let's assume you've got a company which is run by an extremely experienced and knowledgeable CEO, but that person has no legal right of
Yes, you have an entirely passive investor.
Entirely passive investor, as often you might, and certainly in bigger companies, and you would never qualify under 11C on the basis, well, we hired this incredibly knowledgeable and experienced person and he's Swiss, and therefore we are now a Swiss investor, if that person has no legal rights in relation to the company, neither ownership or any legal right to control the company. He's simply a manager. He's a professional manager who's no doubt doing a very good job, but you don't then attribute his nationality to the company for the purpose of the qualifying as an investor under Article 11C. So in law, the fact that Mr. Sava may have been in charge, the driving force, the knowledge and the business, all of those factors are irrelevant when you take full of account of the fact that he was in that position by permission of the trustee who retained control, and he was acting subject to the terms of the trust and as for, in law as an agent for and on behalf of the trustee. So I'm not disputing the factual accuracy of those points, but in my submission they are irrelevant in law and do not qualify as relevant to the question of who in law was in control. I think I've probably made all the points I wish to make, but just let me. So I've addressed the position under the first of the two potential alternatives that Mr. Stava was acting within the framework of the trust and respecting the trust structure. And that is as far as I need to go in my respectful submission. If it were to be contended by my learned friends that Mr. Stava is somehow exercising some form of control external to the trust, which is tantamount to no longer respecting the validity of this trust, then first of all I would object that is not an argument that is open to them, given the way that this trial has been conducted and the appeal. And secondly, there are various other points that we've set out in our skeleton argument, at paragraph 69 to 75, which would prevent that position from being adopted, whether it's analysed as a matter of Liechtenstein law, customary international law, or English law. But I will wait and see how, if at all, those points are developed. The only other thing I wish to mention, unless anyone behind me has anything else, is that I have not so far addressed in any detail the 5 respondents' notice points. Those are each addressed in our supplemental skeleton at CB 21. Some of those points, for the reasons explained there, are not open to the respondents at all, and all of them are either hopeless or wrong. And they are no reason to overturn the judge's fact findings or his reasoning where he was in my favour. And I shall return to those if I need to in reply after I've heard the way, if at all, following our supplemental skeleton, those points are advanced, provided that's acceptable to your lordship.
Yes, that's fine.
My lord, we're all conscious of your direction in relation to parties having equal time, and just make an observation, and I don't invite argument about it, but according to our calculations, we have now reserved to ourselves 2 hours and 10 minutes for reply, which I apprehend will be on Friday afternoon or possibly earlier if my learned friends finish before
Yes, well, I am keeping
adjournment on Friday.
I am keeping a note of time, and I think my calculation looks as if it's broadly in line with yours.
Grateful, my lord.
You're all committed to finish before.
That's now largely in my learned friend's hands.
You get extra points for not using all your time. Yes, Lord Federer.
My lords, my ladies, I will deal with the question of characterization, and I'd like to begin with the scope of the Stava June 2011 objection. As my learned friend Dr. Bustin indicated, we do not agree with the position that they've taken on the scope of the objection in the amended skeleton and also in the oral submission. So I'd like to set out our position. To do so, it may be helpful to begin with the list and descriptions of the objections in the March judgment, so we can remind ourselves of the ground that was covered by objections which are no longer in play. The reference to that is core bundle 12, and it's page 19. Just 1 second to rearrange the thing. So first, of course, there was the no investment objection. It went in our favour on the merits. In addition to the 4 investments listed here, there was a 5th investment, and that is Mr. Stava's shares in Conoco, which was not the object of any challenge. So when we then turn later on to Article 9, and we have the language of with respect to investments, the investments are these 4 investments plus the shares. The second objection that is gone, and that matters for purposes of demarcating the Stava June 2011 objection, is the no indirect investment objection. That's time barred, and the judge described it as the allegation that assets held by Conoco, there's an error there, are not investments of Mr. Stava. This was an objection that had been made in the amended particulars of claim at paragraph 2. Perhaps we can have a quick look at how it was made then. It's core bundle 28, page 2. And it's really the final part, especially of paragraph C, that matters. Further, assets held by Conoco, in which the award held to be investments, are not investments by or made by Mr. Stava. This ground of challenge applies in particular to those paragraphs of the award. the indirect investment objection is gone. Any objection to the investments not being held by Mr. Stava, not being made by Mr. Stava, not being investments of Mr. Stava, that's gone. And if we go back to the judgment, core bundle 12, page 19 again, there was also another objection that was found to be time barred, which the learned judge described as the no nexus objection, which was an objection to the nexus, focusing on the with respect language between the quantum awarded by the tribunal and the investments found to exist. That's also gone. And then briefly, if we turn the page to page 20, we have what the judge described as the no Swiss nationality objection, also gone. Mr. Stava was Swiss at all relevant times, including December 2017. The objection at that point had been put in terms of Mr. Stava not being a Swiss investor under Article 11A because he should have been considered more Czech than Swiss due to his dual nationality, but that's gone. There was then a separate, broader discussion on the nationality of Mr. Stava, and that's also gone. This objection, I think, is important because analytically, the equivalent of the Diag Human 2011 objection is not the Stava 2011 objection. It is rather the no Swiss nationality objection. The no Swiss nationality objection said Mr. Stava is not a Swiss national and therefore not an investor under Article 11A of the treaty. The Diag Human objection, rather more narrowly, says Diag Human is not a Swiss-controlled entity and thus an investor under Article 11C of the treaty as a result of the 2011 events. So they're both objections that take aim at the status of investor. But for Mr. Stava, any objection as to his status as investor is gone. For Diag Human, it remains in play, but only insofar as the effects, the consequences of the 2011 events are concerned. Now, the reason why both the no Swiss nationality objection and the Diag Human 2011 objections are jurisdictional is because they go to the term investor, which appears in Article 9. The offer to arbitrate is extended to disputes with respect to investments between a state and an investor. Is Diag Human investor? Is Stava an investor? Those are all jurisdictional disputes under Article 9. The Stava June 2011 objection is different. Now, the fact that we ended up using these labels, Stava June 2011 and Diag June 2011, I think may have been responsible for some confusion, including perhaps the notion that these two objections were sort of conceptual cousins. They're not. They're unrelated. They share a factual matrix, but no conceptual matrix. They're different objections. And that is why we are having the characterization argument about Stava, but not about Diag. I think that was a long way of answering a question that I think was first raised by Lord Justice Males on day one, trying to really tease out the difference between these two objections. I think it is a fair question to ask, what about a standing objection for Diag Human? Why isn't that in play? And the answer to that is also in the judgment at paragraph 148, page 152. Sorry, page 52. So the judge here begins to describe the Diag June 11 objection, and he says, Diag June 11 objection raises challenging issues which received only limited air and paper time in the submissions. It raises not simply the issue raised in the Stava June 2011 objection, which considered in isolation I would answer in the same way, but the more fundamental issue that if Mr. Stava ceased to control Diag in June 2011, it ceased to be Swiss for the purposes of the investment treaty at that date, and then later on in December 2017. So yes, theoretically, and I think again this goes back to a number of questions on day one or day two, there could be an argument about a Stava June 2011 type objection on standing also for Diag, but it doesn't matter because Diag is a more fundamental problem, which is why the Diag June 2011 objection goes to the question of the status of investor, and the Stava June 2011 objection is a much narrower one. The Stava June 2011 objection is as defined in the judgment at paragraph 123, page 43. Or rather page 44. So the Stava June 2011 objection related to Mr. Stava's inability to claim in respect of conduct after June 2011, or as described in the previous page, paragraph 121, Roman 1. In relation to Mr. Stava, I'm satisfied that the objection is limited to breaches post-dating June 2011. And then I think at paragraph 122.12, sorry for going back and forth, there is also a description along these lines. The Stava June 2011 objection cannot be widened, as my learned friend seeks to do, into an objection to whether Mr. Stava had a proper connection with the investments in a more general sense, or into an objection to the position of Mr. Stava at the date of the arbitration, and I'll come back to that. It is an objection that focuses on his ability to claim in respect of conduct after June 2011, following the events of June 2011, no Karuna and law book transaction. If we go to the appellant's notice, CB tab 1, page 4, we can see that the Stava June 2011 objection is also described in the terms we've seen in the judgment. The appellant wishes to appeal paragraph 1 insofar as it concerns the conclusion set out, etc. But the objection of the tribunal had no jurisdiction to consider a claim by Mr. Stava in respect of conduct after June 2011 was not an objection to jurisdiction. And then turning to the ground of appeal briefly, which is the claimant's ground of appeal, tab 2 of the core bundle. The ground of appeal was set out in that paragraph. The learned judge erred when he concluded that the objection that the tribunal had no jurisdiction to consider a claim by Mr. Stava in respect of conduct after June 2011 was not an objection to jurisdiction. And then later on in this paragraph, the claimant, then appellant now, identifies the specific issue of the objection, which is whether the court should have held that Article 9 of the treaty contains a limitation along the lines that are described then. So it's an objection to his ability to claim in respect of conduct after June 2011, and specifically the objection is whether an implied limitation should be read into Article 9 to the effect that claims for conduct at a time when the investor no longer held the investment should be excluded. That is the objection. In the skeleton for the permission hearing, I think that point is also made clearly. We have it in the supplementary bundle at tab 28.1. That should be one of the core documents, printed documents. But we can have it on the screen as well, pages 2 and 3.
Doesn't appear to be.
Oh, apologies, I thought it was. Shall I come back to it when we have it in print?
Well, we can read it on screen.
Yes. So it's pages 2 and 3, paragraphs 4 and 5. So this is the skeleton for the permission hearing that led to permission being granted in respect of the first round of appeal. Again, the appellant repeats the point about Article 9, and then at paragraph 5, they said such an approach, or rather, if I can start from the end of the previous paragraph, paragraph 4, they say various investment tribunals have held they lack jurisdiction to consider claims over conduct postdating a transfer of the alleged investment. And then they say in paragraph 5, such an approach is consistent with the approach of BIT tribunal to other questions of temporal jurisdiction. Such tribunals regularly read a temporal limitation into provisions equivalent to Article 9 to the effect that the investment must be owned or controlled by the claimant on the date arbitral proceedings are commenced. This demonstrates that tribunals do read offers to arbitrate as being subject to implied limitation. The reason why I'm making this point is because they were very clear that there were two analytically distinct objections. Their objection, and then an objection that focuses on the date where the arbitration commences. So in other words, variant 1 and variant 2 is not part of this objection. Variant 2, they simply refer to it as an illustration of the fact that one can, on their case, read certain categories of limitations into the treaty. But variant 2, as Dr. Bastin put it, is not within the boundaries of the Stava June 2011 objection.
Well, it goes further. It's that they're saying that the types of limitation, these other illustrative types of limitation, are also jurisdictional. So they're using that to make their point about jurisdiction. But your point is, well, they're not running a separate argument that the investment must be owned or controlled by the claimant on the date of the procedure of the start of the proceedings.
That is exactly the point.
That's the point. Yeah.
That's the point.
And you're saying, nor are they running a case, the alternative, that that it's a question of analysis of whether someone was or was not a past investor. It is solely a question of the scope of what has been submitted in
Exactly.
in our
So the narrow issue of the Stava June 2011 objection is on the necessary assumption that Mr. Stava was the investor with the required connection with all of those investments, because that's an assumption they can't reopen. On that necessary assumption, could Mr. Stava claim in respect of conduct after June 2011 when he disposed of his interest?
So, putting it in section 30 terms, you say this could only be a section 31C complaint. It's not an objection to there being an arbitration agreement to which Mr. Stava was a party.
Well, I would say it's not.
It's only a question of whether the claims post 2011 fall within the scope
Let's get to the arbitration.
of that agreement. Is that?
If I'm wrong on admissibility, if they were to be thought of as jurisdictional, which is obviously not our case, because our case is that Stava June 2011 is not a jurisdictional objection for the reasons to which I will come. But if one had to squeeze them into,
Sorry, I understand
yes,
your reservation, but it can't be a 1A case of no arbitration agreement. You say the way the point has arisen, it's only all that was left, as it were, was a point about the scope of what was within it, and you say that's a standing scope, not a jurisdictional
yes,
scope.
exactly. That's a standing scope, precisely. There is a standing scope, whether he had standing to advance a claim in respect of those breaches of that conduct. It's not as a question about him owning the investment, having the required relationship with those investments. It's a different point, and it's quite specific, because the other wider arguments have fallen away, including variant D, and that's quite important because my learned friend is trying to push his variant D, and variant D was really, I have a quote from the transcript as he described it. a claimant must, subject to very limited exceptions, such an expropriation or a forced sale, which we will discuss later, continue to hold the assets at the date of commencement of the arbitration in order to qualify as an investor. So variant D is trying to transform it into an investor type objection and saying there's an implied term in Article 11A that says you must be the investor who still has the investment at the date of the commencement of the arbitration. He wasn't, no jurisdiction. Quite apart from the fact that that would be wrong, this point is not in play because that was not the objection.
Does it follow that the judge has misdescribed the objection in paragraphs 63, 7 and 8? Because 63 subparagraph 7, sorry, my numbers are cut off, so you'll be able to find it. 63 subparagraph 7, where the judge is defining the last judgment, the Karuna Trust objection. The allegation that Mr. Starver did not hold the investments held by the tribunal to exist when the arbitration was commenced.
So, yes.
How is the moment of commencement of the arbitration relevant at all if the objection is the one you're describing?
This is his description of the objections pre-73. So this is how he's describing all of the objections in play, no Karuna, law book, and no control, before he considers what has fallen away because of 73.
Yes.
And the analysis of what has fallen away because of 73, or the result of that analysis, is what we have in paragraphs 121, 122, so this pages 43, 44. It can be confusing, and I think we all, spent a fair amount of time working things out, even those of us who've been involved in this case. But that's essentially, so there were these big objections that he says in those paragraphs, I'm told have been raised. I have to go through the 73 analysis. At the end of 73, what the Czech Republic is left with are these points. Diag Human, is it an investor under Article 11C because of those events? Starver, does it have standing to claim in respect of the breaches because of those events? Why because of those events? Because those are the events in those two paragraphs in the rejoinder that somehow put in play this whole universe.
So you're going a bit too fast now. I'm just going back to where the section 73 is dealt with in relation to these objections. 120 is law book transaction.
Yes, so
that gets through the section 73. So that's not barred by section 73.
so the analysis of the section 73 starts at paragraph 114. So he takes Karuna Trust, law book, and no control objections as one. The reason again being that they go back, they had been raised in the same place. So it all goes back to that language that in the rejoinder is trying to understand whether what objections that gave rise to. And then he applies the test, and his conclusion is, as he develops in paragraph 121, 122, there is a change of language then that perhaps may make that passage a bit less clear, because by the time he identifies what's in play, he no longer uses the no control law book transaction language. So he doesn't say Karuna Trust, law book transaction, no control objections have fallen to this extent. He reclassifies them as Stava June 2011 and Diag June 2011. But those two objections are what is left of no Karuna, law book, and no control.
Yeah, so 120 says in principle, law book gets over the section 73 hurdle. And then 121 says, but I, the judge, have got to look at the exact scope of the objection taken in each case and see whether it, and in relation to Mr. Starver, the only objection that was originally taken, so isn't barred by section 73, is post June 2011.
Correct.
So far, so good.
Yeah.
So, and that's all he has to say about the law book transaction in relation to Mr. Starver. So far, so good.
Yes.
So, just going back to 63 Roman 7, how does any of that affect his formulation about it being an objection by reference to holding the investments when the arbitration was commenced? You said, actually, once we got through the Section 73 stuff, that formulation was in some way amended, but I'm not following that.
Well, that is because of, well, we got 121.1 and it says first June 2011. Then I think if we go to Starver June 2011, the description of the objection at page 51, we see at paragraph 145, page 51, paragraph 145.
When I printed this out separately, it's cut off the bundle numbers, so just give me the paragraph numbers, please.
145.
Thank you.
So the effect of this objection is that even if Mr. Starver is Swiss and made the investments which the tribunal found were made, all of which were made long before June 2011, the tribunal would not have jurisdiction to determine whether or not he retained those investments at the date of the breach for the purpose of determining a claim. On that basis, Mr. Starver was an investor. He made investments for the purposes of the treaty, and then we go through the Article 9 point. I'll come back tomorrow morning on the specific question that I understand your lordship is asking, which is where does that bit of the law book objection falls away for Mr. Starver? It does fall away, but I'll come back to the exact reference. But all of the references that I've taken your lordship to, and most importantly, the first ground of appeal, are clearly limited to the point as I've described it, which is the ability for the standing to claim in respect of breaches, in respect of conduct after June 2011. The ground for appeal for which they got permission does not refer to the date of commencement of the arbitration for Mr. Starver. And we've seen the point in the skeleton where actually it is clear that they're using that as argument but not as an objection. And yesterday, my learned friend at some other point in his submissions, he said when one steps back, this is day 3, page 54, lines 5-9, when one steps back and looks at the Starver June 2011 objection, it is ultimately an objection about the existence and scope of the consent to arbitrate. And again, not sure where that point was going, but there were a number of overreaching attempts to recharacterize the Starver June 2011 objection. It cannot be an objection to the consent to arbitrate because they cannot challenge jurisdiction pre-June 2011. The best that they can get from the Starver June 2011 objection, as defined in their own grounds of appeal, is knocking out conduct after June 2011. That's the best they can get for Mr. Starver. That's the best they can get. But they can't knock out Mr. Starver on the basis of the Starver June 2011 objection. They can knock out that conduct. And my lords, my lady, I don't know if you remember, but when I opened, I started off with this roadmap on the dates of the breaches because I knew that at some point we were going to have this discussion. And on the tribunal's analysis, the 3 main breaches are, in our case, all comfortably before that cut-off line. And the reason why my learned friend is to keep trying expanding Starver June 2011 is because he knows that even if the point were to be jurisdictional, and even if they were to prevail on jurisdiction, he still can't knock out Starver June 2011 because of all the other objections that are out. He can take out the post-June 2011 breaches.
Which is just the latter part of the interference with the review proceedings.
Well, on our analysis, it is not the first breach, because that's Boyer. It is not the second breach, interference with commercial arbitration. It is not really the key due process breaches of the third categories of breaches, because all of the key conduct, including that meeting in 2009, predates 2011. Now, there may be an argument we'll have to have another day if necessary, but that's very much our position.
I mean, I can see some initial force in the argument that it's the interference with the review that matters. Because up till then, despite the conduct of which you complained, you'd succeeded in getting your commercial arbitration award.
Well, we have the breach on the Boyer letter, which is a key breach.
Yes, but that had, again.
This is again, but I'll give your lordship a reference, because I think they will stand up and say that with the Boyer letter we don't get the damages. Again, not a debate for now, but it's things that people are obviously in your lordship's and your ladyship's minds. The judge in his ruling 1 looks precisely at the question of the structure of damages in the award. The reference is, we don't need to go there, but the reference is core bundle, tab 24, page 3, and that's paragraph 8 of his ruling. And he says clearly the Boyer letter is sufficient to have everything in, essentially. And that's our analysis of the damages. But that's a battle we may need to have one day if we are wrong on admissibility and if we're wrong on jurisdiction on Stava June 2011. But I think in order to have the characterization debate, it is important to be clear about the scope of this objection, the scope. And the scope really has to be that ground for appeal, as they themselves put it, and as granted by the judge in the order. I haven't taken your lordship to the order, but it refers to the ground for appeal. I can give the reference if necessary, the 11th of April order. So I think that's what I wanted to say on scope, but I'll come back to a couple of points that have been put to me tomorrow morning. And then, my lords, my lady, the next thing I was going to do was to focus on 2 main areas. The characterization test that applies under English law and the treaty analysis. So those are the 2 main areas on which I'd like to focus. Hopefully, I can complete characterization this afternoon, but let's see. So actually, we can stay with the judgment. Paragraphs 131 of the judgment at core bundle 12. My learned friend went into the international law authorities, but I think it is important to remind ourselves that the judgment is quite cautious about the relevance of the international law authorities and the distinction between jurisdiction and admissibility in international investment law in the context of an arbitration seated in this jurisdiction. The test, as we know, is as set out by the judge at paragraph 131. We're applying section 30. At paragraph 133, the judge says that he was unpersuaded by the utility of the distinction between jurisdiction and admissibility that has been developed in the investment treaty context. And he puts the question that should be properly asked, not as a question of characterization between jurisdiction and admissibility, but, paragraph 133, as a question that says, that asks whether the court, sorry, I'll start again. It says it is a binary issue. The court is ultimately faced with a binary decision whether the challenge brought falls within section 30 or not. That's the test for characterization under English law. I think it may be also useful for the court to see a subsequent judgment by Mr. Justice Foxton in Korea and Elliott. So this is a judgment that was handed down in August. We haven't made submissions on it in our skeletons because our skeletons were served before the judgment, but the parties have of course agreed to add it to the bundle because it is now, I suspect, one of 3 or 4 judgments of our High Court on this issue.
That case is also on its way to this court.
It is, I think, in the next few weeks, I think, yes. And it is at volume 2, at volume 7, and it's LA 29 11.1. I should explain, just by way of background, that the treaty provision in this case was quite different from our treaty provision. So the proposition that we rely on from this judgment is found in the part of the judgment where the judge articulates the principles rather than really the application of the provision. The provision is at page 2, paragraph 7. This was more complex provision. At paragraph 7, you find the provision in the BIT that dealt with scope and coverage, and you see that it started off in the chapeau with the words, "This chapter applies to measures adopted or maintained by a party relating to," etc., etc. This is the equivalent of our Article 2 rather than Article 9. Korea advanced the objections that are set out at paragraph 10 of the judgment, at page 3. In essence, Korea raised an objection to each of those terms in the chapeau. There was no relevant measure, the measure was not adopted or maintained, and the measure did not relate to Elliott or its investment. So that was the nature of Korea's objection. It was based on the language of the scope provision, and in particular of those words. The tribunal had found these matters to be jurisdictional and had rejected the jurisdictional objection. The judge found all of them to be non-jurisdictional. And the dispute settlement clause in this case, just to complete the background, is at paragraph 44 of the judgment. Yes, 44. It was Article 11.16 of the USA-Korea Free Trade Agreement. And again, as we can see, it is a more elaborate dispute settlement provision than the one in this case. And if we go back to paragraph 28, we have an articulation of the principles on which we do place reliance. First, at paragraph 28, in Korea and Elliott, the judge says, it would be wrong to assume that the dividing line between issues of jurisdiction and the merits is drawn at the same point before an investor state tribunal applying international law as it is before an English court applying an English statute. He then refers to section 30 and the ability to re-argue on a de novo basis. And he explains that, now I quote again, raises distinct issues of national policy for the English court, which are not engaged in a meaningful way before the tribunal. To take one example, the significance of distinctions between issues of jurisdiction, standing, and admissibility before an investment treaty arbitration tribunal are minimal. In ITA tribunals, we'll often refer to them compendiously. Before a court, under section 67, they're everything. So he's developing the point that already features in our Diag judgment, but I think it is useful to see how he does it, and we very much rely on this articulation of the principal approach to the investment treaty jurisprudence. At paragraph 31, he repeats the point that what is required in an arbitration seated in this jurisdiction is an analysis of the applicable English law. He then analyzes the decisions of the English courts in paragraphs 32 to 36, including Tatneft again, and including his own judgment in Diag. And then at paragraph 37, he identifies the principles that in his judgment are to be derived from those cases, including Diag, and he identifies 5 principles. I'd like to go through them briefly. First principle is that issues which define those to whom the offer to arbitrate is made will be jurisdictional. Essentially, the meaning of the term investor, to whom the offer is made, and therefore Article 11A, 11B, 11C, those are jurisdictional matters. 2, where there is no express limitation in the offer to arbitrate, there is likely to be a greater challenge in persuading the court that the offer to arbitrate is limited beyond its express terms. That simply reflects the application of the VCLT principles of interpretation to the arbitration offer in a treaty. And my lords, my lady, I will be making submissions on the interpretation of the treaty and on the VCLT in the context of this appeal and also on the other appeal. I think it is useful to note the point that he makes about express terms. Implying terms in a treaty is quite a complex task. It's quite ambitious for a party to say you just need to read this language into the treaty that is not there. And that's why he says basic VCLT analysis under Article 31, good faith interpretation, ordinary meaning, context and purpose. You have to start with the ordinary meaning. To get from there to imply terms that really change the meaning quite significantly is a tall order. Now, if we can perhaps pull up the VCLT briefly, so I'll make this point now. It's LA 95, and it's volume 17. And I think what we have there are just articles 31 and 32. We turn the page, we get page 2. Yes, so page 2 is article 31, which I understand to be common ground is the basic rule of interpretation which we are applying to this treaty. And it's the well-known language. Now, Article 32, if we turn the page, on supplementary means of interpretation, is the provision that says you may have recourse to things like travel preparatoires, etc., in cases where, if you apply the basic rule of interpretation, you end up with a meaning that is ambiguous or obscure, or a result which is manifestly absurd or unreasonable. So, basic rule of interpretation, very difficult to add implied terms on the basis of Article 31. However, if applying Article 31, you end up with something which is manifestly absurd, or something that is ambiguous or obscure, that's when one may have recourse to supplementary means of interpretation to try to, in that case, perhaps read other language that is not in the treaty, because the language itself, in its context, is not clear enough. But that's the interpretative process. They are not invoking Article 32 because they have no supplementary means of interpretation that give them the result which they are seeking. So we all agree we are operating within Article 31. And so the principle, to go back to the judgment in Korea and Elliott, at point 2 is really rather important when the judge says no express limitation, very great challenge to persuade the court that there is a limit beyond the express terms. So there was the principle, the third principle. Then the fourth principle, where an issue involves the application of protean legal concepts in a highly fact-sensitive context, it may be more difficult in the absence of express language in the offer to arbitrate to establish that the issue is jurisdictional in nature. And finally, where determination of the issue said to be jurisdictional would require the supervisory court to determine issues which are integral to the merits, that in itself may suggest that the issue is not jurisdictional. And we adopt these principles and we respectfully submit they are correct and they support our case, and in particular the first 3 principles, but really also the fourth principle too. And these are all this is the analysis in Korea and Elliott. So that, I think, is what I have to say on characterization. It's the test adopted by the judge in the Diag judgment is correct. It is a binary question for the English court. The assistance that one may derive from the ITA jurisprudence is of limited value. And the approach to take is the one articulated in these 5 principles with a view to determining which of these objections are jurisdictional or not. Now moving on to the treaty analysis, I can probably get started on it, at least just set out at a high level what I'm going to say. The Czech Republic's case in their skeleton focused on ordinary meaning first, then context, in particular Article 2, and then object and purpose. In the oral submissions, they sort of slightly changed the order, and they seem to place less emphasis on the actual language of Article 9. They're starting more from other terms like Article 2, but that's essentially their interpretative case. And then in addition to that, they also made a few points about good faith interpretation. So I will look at Article 9, which is the key provision, and apply the Vienna Convention test. As I said, I don't think there is a disagreement between us on the basic rule of interpretation being the right one in this case, absent any supplementary means of interpretation for the treaty. If we take the treaty, which is at SB 22, Article 9, page 5, we've obviously looked at this provision some attention already. I think just note that paragraph 1 identifies the class of disputes in respect of which an offer to consult is extended as disputes with respect to investments between a contracting party and then investor of the other contracting party. By the time we move to the following paragraph, where the offer to arbitrate is contained, the reference is to the dispute. It is obviously the dispute that has to be with respect to investments between a contracting party and an investor of the other contracting party. At 2A, the first sentence says the arbitral tribunal shall be constituted for each individual case. I mean, that simply reflects the fact that by the time the dispute goes to arbitration, there has to be a degree of specificity about the dispute that is being identified. And that also answers my learned friend's point about sending a general letter to the host state accepting the arbitration agreement before there is a dispute. It can't be done. You need a dispute. The unilateral offer to arbitrate is an arm that the state is stretching out to investors waiting for a handshake. But you can't shake that hand until you have a dispute. And so sending a letter and saying, we accept an arbitration with you is not perfecting an arbitration agreement because there's no dispute yet. You need the dispute.
But a conventional domestic arbitration agreement is an agreement to arbitrate disputes, future disputes, if and when they arise.
But this is not how this works.
It's an agreement to arbitrate an existing dispute which has already arisen and which has been through the process under subpara 1.
Exactly. It's in those two steps. All that we have in Article 9 is the offer. But the perfection of that agreement requires the submission of the dispute. And that's when we have the arbitration agreement. And my lords, my lady, it is an issue that has actually arisen in the reform of the Arbitration Act because on the default rule on the arbitration agreement, the proposal of the Law Commission was to have as a default rule the law of the seat. And then it occurred to some individuals that that was going to be a disaster for investment arbitration because it would have meant that that English law would have applied to the arbitration agreement. And that problem has been fixed with an amendment that has been accepted. And once the bill goes through, it will reflect exactly the structure for the perfection of an arbitration agreement in these situations. There is a unilateral offer to arbitrate that is perfected when the offer is accepted. But here, to accept the offer, we need a dispute. We can't just accept it before and say it's been accepted forever in the future for any future disputes, because that's not, the offer is not in those terms. So briefly, and I think no, we've reached 4:15. Article 9 is really quite a straightforward dispute settlement provision. The key elements of the jurisdictional gateway are investments, investor. Those are normally the main jurisdictional fights that one has in these cases for obvious reasons. And then the existence of a dispute with respect to investments being between the investor and the contracting estate. That's what the offer to arbitrate includes. It does not include any other limitations, such as, for example, a limitation to disputes with respect to investments concerning conduct arising while the investment was being held by the investor, or whatever language they would need for their Stava June 2011 to prevail. It doesn't include any such limitation. That's the offer. It's a broad offer. And as long as there's a dispute, there's an investor, there's an investment, and a dispute with respect to investment, we're through on jurisdiction. And of course, as long as the treaty is in force. But none of those issues are in doubt. But on
So those sort of temporal limitations go to a substantive issue as to quantum, for example.
It depends on the type of temporal limitation. The temporal reference in Article 2 only tells us that an investment had to be made after January the 1st, 1950. If it was made after that date, it's a protected investment. Any dispute with respect to an investment, as long as made after that date, is potentially within the offer to arbitrate. However, if the treaty was not yet in force, then you can't try to hold the Czech Republic to account for conduct for which it was not yet responsible under international law. So if I bought a hotel in the Czech Republic during the communist era and it had got expropriated in 1980, I would have no claim. But if that same hotel bought in 1955 or whatever had been expropriated in 1992, then I would have a claim.
I follow that. I was really thinking in terms of once you've got an investment by an investor, any dispute is about when they're holding that investment will go to a substantive question on your analysis.
Well, then on that temporal issue, I think the question would be merits and quantum. Yes, it would be about merits and quantum entirely. Because the investor has the dispute. It is a dispute with respect to investments. And if the circumstances are such that the breaches affect part of the investment, but not the entirety of it, those are all matters that go to merits and they go to quantum.
Well, that's your case, and that's essentially what the judge said in his 146, isn't it?
Yes. Yeah. Is this a good moment?
Yes, very good. We'll resume at 10:30 tomorrow.